Good afternoon. From Oregon, I am Erin Lageson, and I am the presiding judge of Department 3 of the Oregon Court of Appeals.
Good afternoon. My name is Steve Jewett. I'm a county court judge in the Ninth Judicial Circuit of Orange County in Florida, which is Orlando.
Good afternoon. My name is Doreen Hartwell, and I am an attorney in Las Vegas, Nevada.
Students, would you please introduce yourselves?
I'm Shelby Sweats.
My name is Lizzie Gray.
My name is Gabe Knutson.
I'm Toby Kinslow, and this is our instructor, Mr. Gainey.
Thank you. Well, this afternoon, we are doing question 1. As a result of the decision in Wisconsin v. Yoder is that, quote, any parent/guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs. Do you agree or disagree with this result of the decision? Why or why not? What words, if any, are found in the US Constitution or in state constitutions that protect the right to an education? And finally, how have courts balanced religious beliefs with other rights? You may begin.
We disagree with the conclusion made by the quote from the Amish Heritage Foundation. It implies that Wisconsin v. Yoder will allow anyone to withdraw a child from any subject that violates their religious beliefs, as long as they can justify it. This is false. Wisconsin v. Yoder actually states that Amish values are violated in the education students get in their last 4 years of school, so their children specifically do not have to attend schooling after they turn 14. With the correct interpretation of the case, we disagree with the decision. When speaking about the religious freedoms enshrined in our Constitution and history, the Amish are well within their legal rights to withdraw their children from school after the 8th grade. Wisconsin v. Yoder, a 7-0 case presented in 1972, affirms this claim, stating that Wisconsin's compulsory school attendance law was unconstitutional as applied to members of the Old Order Amish Mennonite Church because it violated their First Amendment right to the free exercise of religion. The First Amendment explicitly states that no law shall be passed that infringes upon a person's freedom to practice religion. America was founded on this freedom, and this is how the Supreme Court justified their decision.
However, we believe that even by the 8th grade, children lack the societal and social maturity to decide what's best for their future. Young adults are provided these skills over the first 12 years of schooling from the ages of 5 to 18. Only after high school do they have the skills necessary to make informed decisions about their futures, even though that is debated. Some members of religious organizations, specifically the Amish, are prohibited by their faiths to acquire these skills. In Justice William Douglas's dissent of Wisconsin v. Yoder, he expresses his disdain with how the court solely saw the case as a state versus religion issue. He believes that the court should have placed more emphasis on the potential futures of the children affected. Amish children are not given the freedom to leave the community until Rumspringa. This is a time when they're allowed to go out into the world and experience life as others see it, but the Amish do not get this chance until they are 16. This is their only exposure to life outside the Amish community, and it ends once they agree to be baptized into the church. There's no issue with young Amish people deciding to remain in their faith, but it's important to analyze the education that they're opting out of.
While no explicit right to education is written in any state constitution or the federal constitution, there is financial support in many of them. South Dakota has many examples of land grant institutions. Starting in the Civil War, the federal government started focusing on improving the state of the public education system. Many states were allowed to give out land grants to build universities. Educational policy is the responsibility of local government, while the federal government is more concerned with disparities and the equity of racial, religious, and other groups. A state example would be Indiana, which guarantees free education to all, as well as having required funds for each county to be allocated to education. It is the duty of local government to establish educational institutions and develop academic curricula. The 14th Amendment can also be used to defend the right to education, as any service that is provided by the state must be equally accessible to any and every U.S. citizen. Lastly, the General Welfare Clause is often cited as alluding to the right of education.
There are many examples of case law that balance religious beliefs with other rights. In Hosanna Tabor Evangelical Lutheran Church and School versus EEOC, the courts ruled that although the First Amendment protects religious institutions' employment, the government is still able to limit jobs that are not religious in their function. In another case, Burwell v. Hobby Lobby, the court voted that the Religious Freedom Restoration Act of 1993 allowed a for-profit company to deny its employees health coverage due to religious objections to contraception. This was another case protecting the freedom of religion, allowing companies to base their employees' rules on their religious morals. These cases demonstrate the government's ability to balance religious freedoms with other rights. Every citizen of the United States should be afforded the opportunity for public education. Especially in the current digital age, it is important to have a general literacy of how to navigate the internet, which is provided in the public school system. There are many skills provided in the K-12 system that would benefit children in the Amish community. We are now ready to take your questions.
What does separation of church and state mean in the context of a right to an education?
The right to an education is a government, state and federal law. The government says that everyone should have the right to education. And that means that no matter what religion you have, you still have the same right to education as everyone else, all of the other students in America. So
I believe that the separation of church and state is mainly you cannot teach different religious beliefs in the school curriculum in order to protect the free exercise of religion, because otherwise you would have to teach all sorts of religious beliefs inside our schools. The fact that it's being argued in the case that we were presented is that you're able to withdraw your children if they are being taught something that is not in the Amish faith. However, we believe that the Amish kids have a benefit to learning what is in the K-12 system.
Okay. Should public school students be allowed to participate in religious clubs held on school grounds? Why or why not? And if you have some specific examples, that would be appreciated.
I do agree that students should be allowed to participate in clubs that relate to beliefs. For example, at our school, we have Students for Christ. That is an optional thing and you are not made to go to that club, or you're not forced. So I do believe it is your right to have those clubs within the public school district.
I would have to agree, saying that you should be able to have religious organizations within the school as long as they're not forced upon any students.
and also that all religions should be able to be represented at your school, no matter if it's Christianity or any others.
Well, that was gonna be my question, Ms. Gray. Could, if a couple of students wanted to have a Satanist club, do you think that would be allowed? And should it be allowed?
I think that it definitely should, as long as they're not harming anyone outside of anyone, and as long as they're not inciting any sort of violence, then I think it should be allowed.
Okay.
Mentioned the Burwell case in your prepared statements and summarize the product of the majority decision, but that wasn't the justices had different viewpoints on how the law should work in that area. What were some of the different perspectives, and which one do you agree with and why?
I'm not sure of any of the opposing viewpoints of the judges.
I think that I agree with the conclusion of the case that they shouldn't be allowed to limit the company based on their employment practices. I think that private businesses should be allowed to exercise their freedoms in their businesses.
How should a student's right to an education be weighed against a parent's religious beliefs?
I believe that it all comes down to what is right for the child. And I also believe that it comes down to the line of what is.
I think it always comes back to the freedom of religion versus the child's well-being. It's actually a really tough question because you really want to allow the freedom of religion to everybody, but whenever the child's life or well-being is in play, it's really difficult to answer that question.
And I have to agree with that. I think that the fact that it is children being involved in this case makes it very, very difficult, especially since the parents are supposed to be responsible for their well-being. And the fact of the matter is that when do you determine a child can decide for themselves and what's best for their futures? However, in our dissent that we had in our prepared speech, it was trying to protect the potential futures of these children so they were not to be trapped within their decision.
What about, when you're talking about the religious beliefs of the parents, what about vaccination? I mean, obviously, we have vaccination, and it doesn't even have to be for COVID. Obviously, that's what's in the forefront right now. But vaccination for whooping cough or for measles have basically eradicated that in the United States. And there are places where there are anti-vaxxers who don't want to vaccinate their children because of religious beliefs. How do you, what's the weighing process that you would have in that from not vaccinating the children? It affects their health as well as the health of all the other kids, and whether or not they should be allowed to go to school if they're not vaccinated.
I believe in this instance, you do have to think about the common good. And if the common good is to get the vaccine, then the school or the public or the state should provide that student with other options other than the public school, such as online school or online education, because it is still the parents' right not to vaccinate, but you do have to worry about the other children that are being exposed to that child.
Perhaps if the government subsidized a private school for non-vaccinated children, that would be acceptable. However, I do think it is unacceptable to force parents to make their kids get vaccinated.
You mentioned correctly that there's not a national constitutional right to education. Evaluate the pros and cons of recognizing one.
I think that there are several pros and several cons to this. I think that some of the pros of having it is it ensures that you do have the right to education, but one of the main cons to it is the state cannot personalize it to the needs of their state. For instance, I do not believe that New York should be having the same laws about their public school as South Dakota maybe should.
And I also think that you can relate this to many of the framers having issues. The Constitution is a government of enumerated powers. So if there were a right to education explicitly stated in the Constitution, there may be an avenue to which people can misconstrue the meaning and in effect, perhaps disparage people from education through the very avenue that people were given it.
If I could just jump in, that intrigued me when you said, Ms. Sweat, I believe, or Shelby, that the laws for New York schools should be different than South Dakota. In what way? What do you think there should be? What should the difference be?
I think that some of the main core values should remain the same. However, I do feel that, for example, of course, class sizes may be smaller here or there. And I feel like limits on class sizes or limits on certain CTE classes might change and vary due to the state.
Okay, so more process. Yeah, okay.
Yeah.
All right, thank you. I think she called time on us, so.
She did. Good job. That was really enjoyable to listen to. I especially appreciated your discussion of the case law. I appreciated your kind of very extensive knowledge of education in this country. The discussion of land grants is something that we haven't heard yet today. That was really interesting to hear. I also thought that your discussion of how to evaluate the presence of religious clubs in schools and how to ensure that both met students' needs but also didn't run afoul of the Constitution was pretty sophisticated in terms of recognizing that if it was going to be allowed, the Constitution would require equal and neutral treatment. So nice job.
I liked it. I like how you have a position on Yoder. You took that and then you backed that up from the very beginning. And the balancing of freedoms versus rights is right on the money. You actually refer to the dissent of the case, which we've only heard maybe one other time, which indicates to me that you're reading the case. You're not just reading the head notes. You just didn't look at what the head note says. You actually read the case and read it through and digested it and recognized, because Yoder is it's very limited. The decision basically is it's limited to those special facts, and it's only because those folks are going to be farmers for their life that they say it's okay. And I think that your perspective, I agree with your perspective that it's not allowing those students, because of what happens if they decide not to become farmers? What if they don't want to do, go into the old Amish ways? So I thought that was really well handled. Some of the stuff, with the common good and the test, you could potentially cite to the lemon decision that gives that test. But overall, really good job. And I like how you were ready to come right back at me when I threw the question about New York and South Dakota. I didn't just let it sit there, and you were ready for me. It's like, yeah, okay, I got it, old man. I'll tell you what that means. And you were prepared. So good job, you guys.
Yeah, I echo the comments of my colleagues. I thought your prepared remarks were well done. I liked how you just right out of the gate, you explained how, I'm sorry, I'm going to need to turn the battery in my head. That's my thinking smoke alarm or detector battery is going. I liked how you explained that Yoder isn't as broad as it may appear on its face, and you gave us the correct interpretation of it, and then you gave us your opinion as to why you disagree with it. I thought that was well done, and you supported that throughout your arguments with precedents, and you did make references to the Constitution. I thought your responses to the questions were really good. And I liked how you have your own opinion, and you supported your opinion with, I thought, solid reasoning. Within the and I think I can't recall if it was Shelby or Lizzie who said, with regards to the vaccination issue, whether or not vaccination can schools require it? And I loved how you guys, and when you answered all of your questions, you really did. Even your answers took into account the balance between, the right to your religious beliefs versus the state's rights with regards to public health. And I love that you provided a solution incorporated that in your answer, that, the schools can require vaccinations, but they then need to offer, for the people who are against vaccinations based on religious beliefs, they need to offer them an alternative, an equal alternative. And I just thought that was a really good, well thought out answer. So well done. Good job.
All right. Thank you guys so much. Great job, and have a great rest of your day.